Hi, my name is Roger Behle with Foley, Bezick, Behle & Curtis, and today I'm going to be talking with you about 4 keys to intellectual property protection. And these are broken down into 4 phases, the first being what we call the idea key phase. The business owner comes up with the idea for the business or the product. And before that business owner begins sharing the information with others, it's important to secure what we refer to as a non-disclosure agreement. And a non-disclosure agreement, as the name implies, is a document that the parties will sign, making clear that the information that they share in the course of discussing the idea for the business or the product is going to be kept confidential. And it's not going to be disclosed or used without the consent of the business owner. The second key occurs in what we call the creative phase, and that's where you've taken the idea, you've exchanged the idea maybe with a couple of people, and you've decided you're now going to go forward and bring the product or the business into reality. And that involves contributions not only of yourself as the business owner, but also the contributions of others. And in this second phase, we call the creative phase, you'll want to have any people that you hire that aren't employees of your company, for example, to sign work made for hire agreements. Those agreements are agreements in which the parties, again, have a clear understanding as to who is going to own the resulting work. And there's a common misconception that if you pay somebody for work, you're automatically going to own what it is they create. And that's actually not the case. You need to ensure that there's a written understanding that whatever is created on your behalf is owned by you, and you do this with a work made for hire or an assignment agreement. The third key is what we call the marketing phase key. And that is, before you begin going to market with your product, you'll want to think about how you might want to brand it. And this involves primarily the subject of trademark. And in trademark, you'll want to think of a name or a logo or a combination of those that you're going to use to identify your product. You'll want to do a search to make sure that those logos or graphics you want to use aren't already in use by someone else. The fourth is what we call the actual enforcement or monitoring of your intellectual property. And this is a key that is oftentimes overlooked. You think, I've got my trademark, I've got my copyright, I've got my patent. In actuality, you do need to spend time monitoring the market, making sure that your intellectual property is not being used without your permission. If you find someone that's violating your rights, or you think might be violating your rights, you can often address that with what's called a cease and desist letter. That's a letter you send to them explaining that you own the rights that are at issue and that you want them to stop, and hopefully they will comply with your request and ensure you that they're not going to continue using your rights without your consent. That's the 4 basic keys, and they seem simple, but they are oftentimes overlooked by many businesses before they begin. And sometimes it's too late after you've already started to make your product, sell your product, that you haven't gone back and actually locked these very fundamental concepts down with appropriate documentation, searches, and registrations. If you have any other questions about this or any other topic, feel free to contact me directly. Our contact information is on the website. You can reach me by email also when you'll find that email address on the website. Thanks very much.